just saying, let's put our virtual hands together to welcome Kyle Broadhurst, attorney at law, first time here in the program. Give him a warm welcome as we do to all of our guests. So if you don't know Kyle, he's going to tell us a little bit about himself, but he's an experienced attorney here in the Cayman Islands who's been practicing for almost 22 years. I imagine, Kyle, you've seen a lot in those 22 years.
Yeah, it's been interesting. It's been interesting. Yeah. So for people who don't know who I am, my name's Kyle Broadhurst. I'm the managing partner of Broadhurst LLC. That's a firm that's located only here in Cayman, and we can trace our roots back nearly 30 years. And as Sandy said, I've been practicing law here for 22 years, and my primary focus is on litigation. And so all shapes and forms of it. The only kind of work I really haven't done over the years is criminal work. Thanks very much for having me on, Sandy. I really appreciate it.
Yes, absolutely. So your topic of discussion today is one that falls on the heel of a very interesting show yesterday, but it's something that really we're always talking about in some form or another, and that's debt collection. So this is so, incredibly interesting because it's a topic that impacts a lot of people. So where do we begin with this? I'm sure you probably get a lot of calls all the time, people saying, hey, so-and-so owes me money. What do I do?
Yeah, sure. So I thought this would be a good place to start our series of discussions, just because I thought it was something that most people get involved with at one point or another. They decide to lend some money out, and I think what happens here in Cayman is a lot of this happens very informally, and then there's a lot of trust.
Sorry, Kyle. Would you have one caller in the line? Let's just grab this call real quick. Morning, caller, and welcome to the program.
Good morning. It's my first time.
Yes. Oh, good morning, ma'am. How are you?
I'm fine, thank you. And you?
Very good, thank you.
Yes, I want to talk about NAU.
Okay, can I get you? We just got a guest in, attorney Kyle Broadhurst, who's talking about debt collection. And then he's going to be on for probably about half an hour or so, and then we're going to get back to the NAU discussion. So can you give us a call maybe after 9 o'clock?
Yes, no problem.
Okay, all right, my dear. Thank you so much.
You're welcome.
Okay, dear. All right. So, want to keep on topic. Our guests in the studio. So, yes, Kyle. Mm-hmm.
Yeah. So as I was saying, it's something that normally impacts everybody else. There's a lot of trust, and people tend to lend money, and then there are people out there, I think you mentioned earlier, that take advantage. And so what I thought we'd do is talk about, first of all, some things you can do to sort of help protect yourself at the beginning of that kind of relationship, or even during it when you have a debtor-lender relationship, and also then what to do if someone stops paying the debt or refuses to pay the debt. So just starting with the concept of what to do at the very beginning. One of the most important things is to document the debt. So if you're going to lend somebody some money, in a perfect world, yes, you'd have a loan agreement or something that's written and signed and dated and so on and so forth. But even if you don't have that, that's not the end of the world. What you can do if you're going to lend somebody money is you can keep it simple. You can have some sort of contemporaneous, so something you make at the same time as you lend the money, whether it's a WhatsApp, an email, and it's going to set out the basic terms of what you're doing. So it's going to say, I'm lending you $800. It should say the amount, it should say who it's being lent to, it should say when it's supposed to be repaid. So, and also if there's going to be any interest attributable to the debt. So if you're going to charge any interest related to it. And if you get those basic components in, even if you just have a simple WhatsApp message with the person confirming, yes, that's what's agreed, then at least you have the basic terms of what you need. And then even if you haven't done that, and you're in a situation where you have lent money out to someone and they're making payments towards a debt, you can still document that. So as they make a payment, you could send a communication to them saying, look, you've made another payment of $100, you still owe me $600, and just confirming when they made the payment and the date. Now, that's important because if you come to a situation where someone starts to deny the debt or refuse to pay it, you want to have some sort of evidence that you can rely on to point to show that the money was lent. Now, it's not necessary to enforce a debt to necessarily have something in writing. It's just a lot better to have that. And it's really the reason for that is just that you have something that you can prove it.
Yeah. Because we've seen this all the time. A lot of us have watched Judge Judy or whatever, and that's the first question: is show me the evidence, show me how this agreement came about. How was this money owed? What was it for? Because sometimes it wasn't a debt as such; it was a gift. So someone gave you money, And now, the relationship has changed or whatever, and you want to say that it was a loan and you were supposed to pay it back. But if that was never the agreement, if it was like, here's $200, I'm giving this to you as a gift, go enjoy yourself, go shopping, you can't come back after the fact and try to change it and make that into loan, right? So that's one of the reasons why having it, as you said, having something in writing to speak to the nature of what the parties were agreeing to is important. But it doesn't mean that if it doesn't exist that you can't still pursue it. It just becomes more difficult.
Yeah, and your gift example is a good one because there's different presumptions that show up as a matter of law depending on who the parties are as to whether it's a gift or not. So look, flipping this on its ear for a second, and if someone was to give you money, then it makes sense for you to send a thank you note or something else confirming it's a gift just for your own protection down the road. And so then there's something that's been sent to them that can be documented, and if they don't then respond saying it wasn't a gift, then you have something you can rely on to try to document the other way.
Right.
So that's.
I must say, one of the beautiful things, Kyle, in this day and age, is because everybody almost tends to communicate on WhatsApp or email or something. There is normally some voice note, some form of, hey, this is what we're agreeing to, meet me up at the local Burger King so I can loan you the $500 and, yep, I need it back by payday. So I think modern technology has really made it a lot easier for people to not necessarily have a formal contract in place, but still have evidence that a contract existed.
Right. And I think that, look, we're all normal people, and not everybody prepares a full written agreement whenever they're going to lend a small amount of money or even, something slightly more. So yeah, documenting it. And then I think also be wise to the fact that if you're going to document something like that, or if somebody sends you, if you've lent somebody money and they send you a text saying, thanks very much for the gift, well, then you need to respond to that and say, no, it wasn't a gift, and deal with it right off. It's not something to be ignored because that could blow up in your face later. So that's sort of some preliminary sort of steps, or some steps to take even during the loan, as I mentioned. So if you have money, you've lent it out, as I say, document it. And no one can really be upset for you just stating the facts as the way they are. Some people are embarrassed or frightened or whatever, but there's no reason to be to at least say to people where they're at with respect to these kind of things. Now, unfortunately, there will be situations where someone will default on a debt for whatever reason. It may be that they're just don't want to pay, or they can't pay, or whatever the situation is. And so what I thought I might talk about this morning is just one of the routes that's available, or one of the primary routes available to people. That's something that they can actually do themselves. And it might sound intimidating at first, but it actually isn't as complicated as people think. And that's to be able to bring a small claim in summary court. And one of the beautiful things about this is that you actually don't need a lawyer for a simple debt in summary court. It's just a matter of having a little bit of knowledge. And what I thought I'd do is I'd talk a little bit about how that process works. But the thing about this is that there's actually really good materials available online, Sandy, and maybe I'll get you to provide you these links. There's a small handbook prepared. So anybody who has this kind of issue and is trying to figure out whether or not they want to bring a claim can certainly go through that. And what I'll do is we'll just talk through some of the basics about how it all works so people can understand it, but then they can get more information from that. So first of all, let's just talk for a second about what the summary court is. It's we have the two courts here, the summary court and the grand court. The summary court is really our small claims court. For civil matters, it'll take claims up to a value of $20,000. So if the claim is worth more than that, then you're going to need to go to the grand court. But if it's less than that, then summary court's your place. And as I said before, it's a court where people or parties are able to represent themselves. So the court is very accustomed to people coming in and without attorneys. And so there is quite a bit of assistance that's available to you. And it's particularly well suited for collecting small debts because the court process is a lot more straightforward, and it's also a lot faster than bringing a claim in the grand court. So the process for the summary court is to well, first of all, the first thing you should do, actually, if you have someone who's defaulted on a debt, would be to send them what they call a letter before action. Now, that's sort of a formal term, but it's not that formal of a document. It's really something that's being sent to them saying, look, you owe me this money. I lent it to you on whatever date it was. You didn't pay it back. I am now demanding that you pay it to me. And if you don't pay it to me, then I'm going to take action against you. And sometimes that'll be sufficient to cause the person, because obviously nobody wants to be involved in litigation. But if it's not, then the next step would be to go ahead and to issue a claim, or what they call a plaint, in front of the summary court. Mm-hmm. Now, a plaint is a reasonably simple document. There's forms available to you, and the important information that has to be on it is basically who you are, who the debtor is, and then the basic information about what happened. So effectively, I lent money to this person on such a date. It was this amount. They made these payments, or they didn't make these payments, and this is the amount I'm now claiming from them. And what happens is there's a small filing fee in relation to that. I think it's $25. And then once that document is filed, it needs to then be served on the person. And I understand people don't want to probably have direct contact at this time. So what you can do is you can actually have service effected through the court bailiff. And that's not terribly expensive either. I think it's based on locations. I think maybe in Georgetown it's $30, and if it's in debt, it's like $75.
Right.
Once that document's served, then the person who's the debtor or the defendant, who we refer to them as, and has 14 days to file what's called an acknowledgement of service to that document. Mm-hmm. And that document's either going to say that they don't contest the debt, maybe they say they need more time to pay, or if they are saying, for example, using your example, they're saying, well, this was a gift, then they need to file what's called a defense. And the defense has to state all the particulars, all the facts that they say means that they don't have to pay. And so what can happen there is we have sort of two different situations. We can have, if they say that they aren't going to contest, then you can move immediately towards getting a judgment against the person. And if they do contest, then the next step is for the matter to be put down for trial. Now in grand court, we'd have a whole bunch of other steps that would take place. But in summary court, effectively what happens is you fix a notice to fix the trial date. You then, a court date would be set, and then on the day of the trial, you'd be expected to come along with all your documents. So in this case, if we had our direct messages or our emails or whatever we have evidencing the debt, and then we'd have that and any witnesses. So if there was someone there when you lent the money that can speak to it, or there were subsequent discussions where the person admitted they had borrowed the money or whatever, you bring your witnesses. Both parties bring all their witnesses and they appear before a magistrate. And then that magistrate will hear all the evidence and then give a decision on the matter. Mm-hmm. So that takes you through the process. And hopefully, if you've documented things correctly and you've got your evidence marshaled, you're going to get a judgment. And so then you get into what's called judgment enforcement. And there's just three things I'd highlight there swiftly. Is that one of the things the court can do once a judgment's been obtained against a defendant or a judgment debtor is they can summon the person before the court to be examined about all their financial assets. Mm-hmm. So what that process looks like is the person literally gets an order to appear before the magistrate. The magistrate will ask them all sorts of questions, and you're normally be entitled to ask questions as well. And from that information, you'll be able to normally find some way to enforce the debt. Often what happens is when that process occurs, there'll be some sort of payment plan or something else that'll be agreed at that stage. Mm-hmm. If another method that can be used to enforce the debt is what's called an attachment of earnings order. So if the person is employed somewhere and you know that, you can get an order which effectively requires their employer to pay a certain amount of their monthly salary to the court, which is then paid to you until the debt is paid in full. And the last thing I'll mention here, there are other ways to enforce debts, but the last thing is a charging order. So if the person has property, typically land, it's possible, it's possible to get an order that when that land is sold, you have to be paid effectively first before them. And so that's sort of a simple, very basic outline of it, but that hopefully gives people an idea that there is this path forward through the courts that can be used.
And sometimes people, I've noticed, get confused. Like I've heard people say here, oh, there's no small claims court. Cayman needs a small claim court system, but this is the equivalent. It's just a different term that we use in this jurisdiction. But summary court is basically the equivalent of what they call small claims court in other jurisdictions. Yeah,
that's exactly right. I mean, that's the thing. I mean, it's used where people probably come across it a lot is that, you'll see banks and things like that using to collect on small loans, and that's probably what occupies a large part of the summary courts list. But there's no reason why private individuals can't use it as well. That's what it's intended for. It's not, people aren't supposed to be left in a situation where you're, without a remedy. I mean, that's the whole point of having a court system, right? And that's what the summary court's there to do.
And Kyle made mention, I'm just going to pull this up here on this screen. He made mention of this very useful handbook. It's been around for many, many years. The Office of the Complaints Commissioner, which is now, I think they've renamed it. It falls under the Ombudsman's Office. Put this document together years ago, and it's extremely helpful. So I would recommend that you get a copy of it, and it kind of walks you through all of the steps that you need to kind of get your case started for small claims. So it tells you about what small claims is, what it is that you need to get together, how the process is going to work. And then it actually tells you, and you can see section 3 here, from the plaintiff's perspective. So these are kind of, I don't want to say fancy words, but these are the proper legal terms. The plaintiff is the person who's actually bringing the lawsuit. So if you're the one who's going to file the documents, you're suing somebody else. In civil matters, you're referred to as the plaintiff. And then, of course, the other person on the other end will be the defendant, because they're going to be defending potentially, if they have a defense, the lawsuit, right? So as the plaintiff, this goes through and tells you exactly, what you need to do in terms of documentation. It explains what a cause number is. Because when you've never done it before, all this stuff looks very, very foreign. You look at these legal documents and you think, oh my gosh, this is so hard and it's so confusing. But really what Kyle is doing here today is demystifying the process. There's nothing, spectacular about it in a sense. It tends to be very, very straightforward once it is a debt in particular. And so this handbook, along with the knowledge you're gaining here this morning, will assist you in moving forward through the process. So get a copy of this handbook. I'll put the link here for you guys to be able to download it. And then this goes through and it explains everything to you, even how you do calculations for interest that might be owed and so on, and what the court will accept. And then here's how this is the actual form of what your initial document filed, which is called a plaint. This is what it needs to look like. And it also then tells you, how you can do the particulars of claim. Like it shows Kyle here that this is even handwritten in. A lot of people type it up, but you don't have to type it up. You can handwrite it and the court would accept it same way.
Yeah, it's a really, hats off to the complaints commissioner of the office for putting that together. And I suspect that the reason why they did that, or one of the reasons why they did that, is they would obviously receive different complaints and they'd have to recommend people to the summary court. But yeah, look, if you have questions about these issues, it's available online. It is a really good resource. It even takes you through, as you mentioned, how to draft these claims. I saw there's a question here from someone, Charlene.
Yes,
Broadhurst.
We've got a couple questions. So first of all, First Lady Jeanne says this is very good information. Alejandro agrees. He says it's nice to know. Marie says the best thing is not to lend people any money. Well, sometimes it's not just a loan. It might be a debt where you've provided a service for someone.
Yeah.
Remember that term can be very broad, right?
Yeah, well, yeah, and also the other thing here too, what we're talking about really, I use debts as an example because it's kind of the simplest claim for people to understand. But
right,
if you have, let's for example, it could be a situation where you've rented a property and you're having a dispute with the landlord concerning the return of your security deposit. Okay, yeah. Same process here we're talking about here. So so this information, this small claims handbook is really, and I think it even identifies the different types of claims that can be brought. So yeah, it's really useful information.
Okay, so Charlene says, when you've got receipts when the borrower begins to repay but stops and has no intention to pay the balance, what would you recommend? So this is a quite a good question. The person starts paying, they're paying kind of piecemeal, and then they stop for a time. Do you keep going back and forth with them, or at some point do you say, okay, enough is enough?
Yeah, so what I think you do in that situation is I would prepare what's a letter of demand, effectively. So that's going to be a document that's going to set out the very basics of what happened. So when you lent them the money, what payments they've made, what the balance is, and then if they're refusing to pay, you could say that in there, and then say to them, look, I'm demanding that you make the payment within 14 days or 7 days or whatever it is, or resume making the payments, whatever relief you want. And if you don't do that, then I'm going to bring proceedings against you. That'd be the first step, and see if that doesn't knock things loose. And if it doesn't, well, then I think you need to be going and having a look at the small claims handbook and looking to bring a claim through the summary court, assuming that the debt is less than $20,000.
Mm-hmm. So, yeah, there you go, Charlene. That's the way to do it. And you see this too. A good example of this, Charlene, when you think about it, or banks do it, right? So, you might be in trouble with the bank and you run QuickTime and find a few dollars and pay them. And they say, okay, we don't really want to try to take you to court for a couple $1,000s. And they'll give you an opportunity. But if they see that, you pay and then you don't pay and, they're not going to continue to go back and forth with that. They'll send you a final demand letter and saying, hey, you need to pay the full amount within 7 days, whatever. And then if you don't do it, they kind of move on from there. So Everton has a question. He says, what if the person who has money for you, you go to the court system and they were told to pay the money back and they started and then they stop and you garnish their wages or put a lien on the individual property. So this is a case now, Kyle, where you've won the judgment because there's two, and it's good to make sure that people understand this. There's two very, very distinct parts of the process. So the first sort of major part is you actually win the judgment, right? So the court says, yes, this money is owed and this person has to pay it. That's almost in some instances the easy part. The hard part is the second part of that. And how do you collect that judgment? Because now, you got to get paid. You've got to get the money. So Everton's question is, they're garnishing wages. They can put a lien on property. The court has certain enforcement powers. There's a number of enforcement powers. But if the person starts to pay and then stops, do you then have to go back to the court to inform the court, that they're not adhering to whatever they've been instructed to do, so that they potentially are in breach of an order?
Yeah. So we're assuming here for Everton's question that he has obtained a judgment and that there's a court order requiring the person to make payments. So if they stop making the payments, they're in contempt of that court order. So there's a number of different types of relief you could bring forward, but yes, I mean, the answer is he's asking whether you could garnish their wages or put a lien on their individual property. Yeah, that's potential remedies that are available to you if they've stopped making payments. I mean, what you would do is you would bring it back before the court because they are in contempt of court for failing to breach. The court actually technically has the power to imprison someone, but it's not normally what's done. And depending on the amount of the debt and if the person's employed, then yeah, that would be good grounds for seeking an attachment of earnings order. Or if you're aware that somebody else or they're obtaining money from some other source, you might be able to get called a garnishing order against the person as well, which requires that third party to pay whatever they owe the debtor to you. So there's different types of remedies that are available. I think that the one thing to do about these things in all scenarios, actually, I probably take a step back here for a second, is not to ignore it. Don't let these things drift and don't let the court orders go on forever. There is limitation periods involved. Generally with a simple debt, it's 6 years. So, be mindful of someone, especially if they keep putting you off and saying, yeah, I'll pay you, next year or whatever. At some stage, you will lose the right to be able to pursue them if they haven't made payments towards the debt. So be mindful of that.
Can I ask you about the limitation period? Does it run? How does it work? Is it a situation when the person starts a court action, or is it they're allowing you to not make payments? What part of it is like
so normally it's a 6-year period from the time of the breach, and so this can get a little bit complicated if you don't have a written document because you have to figure out when the breach is. So look, the safest way to look at this is that unless you had a specific date of payment, so if when you lent the money there was a specific date agreed and you can prove that date, so you have something in writing. And the safest rule here would be to make sure that if you're going to issue proceedings, you do so within 6 years of the actual date of the loan. All right, that's the safest way. You'll know you'll be within, and don't leave it to the last day of it, obviously, because you can run into trouble that way. So 6 years is the general rule. The limitation period can be longer in other circumstances, but just for the purposes of this discussion, don't leave it longer than 6 from the date.
Okay. All right. Very good. So Everton has another comment. He says collecting debt from someone is the hardest thing because if they refuse to pay you, they don't care about the court system, justice. They just don't care. So don't lend more than you can afford to lose unless you're going to take care of a situation a different way by doing what is necessary. Sometimes you have to do what you got to do for your own justification. So to be very, very clear, Kyle, I mean, you never recommend people taking matters into their own hands when it comes to recovering a debt, because that's where you get in trouble, and you're the one who's going to end up on the wrong side of the law, right?
Yeah, exactly. I mean, there's a whole slew of problems that'll be much bigger than the fact that somebody owes you money if you do something. I mean, something silly. So yeah, that's not the way to go. But there is routes available to you to collect debts. Now, look, there's going to be circumstances where some people, you can't get blood from a stone, sort of thing. So if someone has fallen into hard times for whatever reason and they have nothing, then the court can only make them pay what they have access to, right? But often people say they have nothing, but they really do have something, and they're just not being honest for whatever reason, or they think that because it's been so long, they shouldn't have to repay you, or whatever justification they've come up with their own mind. And that's the purpose. I was talking a minute ago about the ability of the court to pull someone in and to examine them about what they have. That can include requiring them to turn over their bank records and everything else, or getting information from their employers, all of these things to see what's actually going on. So the person who says they're broke, but it's driving a brand new BMW or whatever the case is, I mean, the car can be seized as well. There's different avenues available. So the court is more robust than I think people realize in most instances. And yes, it does take a little bit of knowledge to be able to know what to do. But the purpose of this is not really to flag the need to go get an attorney for these things. It's really to flag that there is this this capability to take steps. So some people shouldn't just walk away from these things.
Yeah. This is a self-help remedy.
Yeah.
So Ryan says, for 20 years, my go-to remedies for debt collection has been small claims court for amounts less than $20,000. So that's important, again, to stress that there is that limitation on the amount of the debt, right? That you're eligible if you want to stay within small claims court or summary court. And the filing of a statutory demand on corporate debtors. Please ask your guest to explain what a statutory demand is and what the possible implications are to the debtor. So what is a statutory demand?
Yeah, so a stat demand, I won't get too far into the weeds on this, but this is when you're dealing with a corporate. So I was thinking more about people to people, but if you'd lent money to a company and the company has failed to pay the debt, you can make what's called a stat demand on the company. And then if it fails to adhere to the stat demand, then the company can be placed into liquidation. Now that gets into a whole other sort of complicated side of life, liquidation, how all that works. But a stat demand is a particularly threatening thing against a company. So it is something that could be considered.
Yeah. So you can, just like you can sue an individual, there is the option to sue companies as well, essentially.
Oh, yeah. Oh, sure. And sorry. And yeah, so a stat demand is just a different, it's embarking on a different type of process. So it's not something really that I was thinking about. It's not how look, it doesn't matter who you lent the money to. If you lent the money to a company, you can sue the company. Now, often what happens down here is people have whatever business entity they call themselves, but it'll be somebody trading as whatever. And so that's not normally a company. It's often just the person themselves. So you do need to know who you lent the money to. And here's one thing. So on that point, so sometimes people lend to, Joe Blow's car business or whatever it is. And then that business goes under and the person says, well, the business is gone. And so I don't owe you the money, or nobody owes you the money. You do need to know who you lent to. So if you lent the money to Sam Smith and Sam Smith's car business went under, that doesn't necessarily mean you can't go get the debt from Sam Smith, because it depends on whether he was actually operating under an incorporated entity, an actual company, or whether it was an unincorporated entity, which means it was just really Sam Smith holding himself out as Sam Smith's motor shop. So know who you're lending money to, and just because someone says a business failed, make sure it wasn't, because it would still be a personal loan if that entity wasn't incorporated.
Very good. So Ms. Charlene says, thank you, Kyle. A lot of valuable information, very much appreciated. Now, Everton makes the point. He says, who will pay the lawyer's fees? So the point of today's program, Everton, is what Kyle is talking about. Is this option available in small claims court where you don't need a lawyer? You can actually do this yourself. So here's a lawyer trying to give you good advice and help you save money. You don't need him if it's less than $20,000 and you feel like you can handle the process yourself. Because obviously, if you hire a lawyer, sometimes, Kyle, if somebody only owes you $500, it doesn't make sense to go hire a lawyer to try to recover that kind of money.
Yeah, no, that's right. But I mean, look, there is a capability to recover some legal costs in the summary court. I think the limit is up to $2,000 that can be recovered in legal costs. Now, the problem is that lawyers are expensive, and taking a matter all to trial will probably cost you more than $2,000. So, but that you could, you might be able to get some advice on certain points if you need it. Or, another thing here, just taking again another step back on all of this is, this is why I started with it, is it's really important to make sure you document these things at the beginning. You do yourself such a favor of just making sure that the basic terms have been agreed. And anybody who's asking to borrow money from you should be more than willing to agree what the basic terms of that are. They certainly do it before you give them the money.
Yes.
And don't be afraid to do that, because it's for both your protection. And if you need an excuse, you can say, look, I completely trust you and I know you'll pay it back, but if you got hit by a bus tomorrow, I want to just have this documented because I don't know who will be responsible for your affairs, or whatever. Something you can sugarcoat it if you want to, but take this basic step to protect yourself.
That's good. That's very good advice. So Marie says that she lent a friend money for mortgage arrears. Both her and her husband work, but she lent it because they had small children. I did not want to see them out in the streets, and thank God I got it back. So good for you, Marie, that you got it back. Now, this is one of the things I always caution people, because sometimes, Kyle, there's a saying that an ounce of prevention is better than a pound of cure. So sometimes you want to avoid situations. And, someone else said earlier, just don't lend people money. That's sort of a good principled position to probably take, and you'll find yourself in less stress throughout your entire life. But I would think that if someone is already in arrears, say with the bank, or they're having financial difficulties, or they're behind in their car payments, that's probably an example of the last person in the world that you want to loan money to, unless it's a gift. You're just giving them the money. It's a gift. And, like you said, kids are involved. You're trying to help them out, but they're already having financial difficulties. It's like when I see this with the bank, I always tell people, listen, I can't fault a bank if you've been in arrears and you've got bad credit. And, now you're running to the bank saying, oh, let me refinance this. They're like, why would we do that? You can't pay now what's owed. So it's a little bit of like, use some common sense when you even think about, is this a person that I want to loan money to or get in business with, or, whatever. Be cautious.
Yeah. And I think also for someone who's in that situation, starts falling behind with payments or something like that, the other piece of advice I'd give on that is don't ignore it. If you fall behind on your mortgage for your home or something like that, and the bank starts taking formal steps against you, don't ignore those steps. You place yourself in a really bad position. So, and you basically leave yourself, you don't really have any room to negotiate these things. So it's better off if you find yourself in a difficult financial state to take it head on and not put your head under your pillow, and try to speak to the bank and try to arrange a new payment plan or a new financing, and be proactive about these things. Because if you're reactive, I promise you, once it goes on to the attorneys and they start the enforcement
there's
steps,
a point of no return.
Yeah.
Very good. So First Lady says, I don't lend people money, period. When they ask to borrow it, I never have any simple, because I don't like foolishness, and I work too hard for my money for someone to borrow and don't pay it back. Everton was asking, why can't we go back to the olden days where we could just do it on a handshake? Well, those days, it no longer exists if you want to try to recover your money should something happen. Everton also says, that's why I made that offer yesterday. I bought $500 because I knew the guy wasn't going to show up. And that is so sad. And that's the problem, that we're dealing with money. It's really hard to come by and lose that much. Goodness, such a crazy runaround. Yeah. Okay. All right. Alejandro is thankful for the information this morning. He says this can work in summary court if you have sufficient evidence. In the process, I've used summary court before, and I must say that the magistrates that, sort of oversee the process and make the decisions, they're very understanding if you're handling it yourself. They're very understanding that you're a litigant person. There's really nothing incredibly difficult. You just have to go through the steps and go through the process. And serving your documents properly, like have a professional person serve it. It's worth the $25, $30 or whatever that you're going to pay. There's a couple people, that's what they do for a living. They're process servers. The court has a court bailiff, but sometimes they're a little bit slow, but there are private companies and individuals who also will serve the documents for you. So, Let's talk a little bit about the acknowledgement of service, because this is quite important. So one of the documents that you attach to the original plaint is an acknowledgement of service, which basically gives the defendant 14 days to acknowledge that he or she has received the documents. And then if they're going to defend it, they would say, yes, they intend to file some sort of a defense. If you forget for some reason to file the acknowledgement of service, I think the court isn't going to accept your documents anyway. They would say this is incomplete. But why is it important for the court to know that the person has been properly served?
Yeah. Okay. So we're talking about what's happened here now is someone's issued a plaint. They've had it served on the defendant, and then the defendant, that document, the plaint is going to say you need to file this acknowledgement within 14 days of it being served on you. And so this is a critical document if you're a defendant, because if you fail to file the acknowledgement, then they can enter default judgment against you, which means that there's no longer going to be a fight about whether you owe the money or not. There's going to be a fight about how you're going to pay it. Now, there are circumstances in which that default judgment can be set aside, but let's just put it this way. If you ever get served with a plaint, make sure you file your response in time. And you have a few different choices when that document presented with that document. One is if you don't dispute the fact that you borrowed the money, then you can check the box saying you don't dispute it. But if the issue is that you need time to pay it, I think there's a box there that you can check on that, which the result of that will be that, yes, you'll be ordered to pay it, but there'll be then a process by which how you pay it will be determined. Now, if you do dispute the debt, because we go back to this gift example, you say, no, it wasn't, it was a gift or whatever it was, then you're going to need to, with the acknowledgement, you're going to need to file a further document or attach to it what they call particulars of defense. And all that really means is all the relevant points to the facts of your defense. So, yes, I got the money, or no, I never got the money, or whatever the heck the reason is, and then all needs to put down on that document.
All right. So First Lady says, thank you, sir. Such important information. I really appreciate it. You never know when you might need this. And as who was it earlier that mentioned, Ryan mentioned that especially if you're a small business owner and, you provide services for people, sometimes you find yourself in a situation where you're going to have to try to recover money that's owed to you. So this is absolutely valuable information. So anything else that we want to cover on this today, Kyle? I know.
I don't think so. You the last thing you just said was a great example of it. So you have small businesses that lend money and they're sending invoices out, and the invoices aren't being paid. And so, the other thing too is that there's the capability to claim interest. And then I think someone just made the comment that there's a legal aid department that's available too. And absolutely, that's another route that's available to you. If you're not comfortable in doing this yourself, you can make an application for legal aid. But that, it's not just if you're not comfortable, you need to be able to satisfy that you need the legal assistance, the value that you can't afford to hire a lawyer to assist you. But that's that was the message I wanted to get across today, Sandy. So thanks very much for the opportunity. I really appreciate it.
Absolutely. So Kyle's going to be joining us on a regular basis. Touching on a number of different areas of law, educating the people. Obviously, if you need expert advice, his law firm is available. They don't do criminal litigation, but they'll do civil litigation and other kind of related contractual matters. And I want to give Kyle and his team a big shout out because they saved me from $105,000 judgment, which would have obviously been devastating. And, having his team come on board and handle that whole John Felder situation, which most of you are well aware of, was a lifesaver. And the biggest mistake I made, and Kyle said it this morning, do not ignore any part of the process. So I acknowledged it, said, yes, I'm going to file my defense, and didn't file my defense, and certainly didn't do so within the allotted time period. And that's a mistake. So you gotta, if you need legal advice, go to someone like Kyle. They're the experts. Let them get on top of it for you. But don't ignore it. Don't stick your head in the sand for whatever reason. Get on top of it and stay on top of it. So thank you so much, Kyle. Really appreciate you coming on today.
All right. Thanks, everyone. Really appreciate it. Thank you, Sandy.